full of whispers, alibis thin. Two sharp-eyed sleuths say, all right, who sinned? Has tip low, clues fall in line. They read between the lines, right on time. Grim starts sweating when the squad rolls through. Every story tested, most don't stand up to prove. So grab your fedora, jump right in. True Crime Squad's on, and the trouble begins. Join the super squad, bonus laughs, deeper clues. Same sharp sleuths, just extra clues.
Hey everybody, and welcome to the True Crime Squad. This is Katie Weaver, here with my sister, co-host, and partner in crime, Kristi Brower. Hello.
Hello. Hey, everybody.
How's it going?
Pretty good. It's a red letter day here in True
Right.
Crime.
My God, the justice system did what it's supposed to for once. I shouldn't say for once. That's kind of unfair, but you know, we've seen some real injustices lately, and today is not one of them, so that's pretty damn cool. Yeah.
Yeah.
Aaron Spencer, the case against him has been dismissed, so there will be no murder trial for Aaron. He's done.
Nope.
He can just
Well
focus
done.
on running for sheriff and
He
trying to
can
clean
go
up,
ahead and just win sheriff.
and clean up their county because they clearly need it. And you'll really double down on that when you hear. We're going to read the entire order today. It's absolutely insane and amazing. And I'm so happy for Aaron. I'm sitting here so dumbfounded right now that this ever made it to as far as it did, especially after
Yeah.
being in front of the Supreme Court twice. Oh,
Yeah.
Aaron, what this family has been through is just unbelievable, especially after you hear what the judge has to say.
Yes.
But before that, one of our dear listeners reached out yesterday because her nephew has been murdered. And we wanted to talk about that case first and put some light and sunshine on that. And we'll continue to put light on this case as it rolls out. But Kristi, I'm going to turn it over to you for a crime news update.
Yeah. Friends, this is Nathaniel Potts. Nathaniel Potts was a 16-year-old sophomore at El Dorado High School in El Dorado, Illinois. Nathaniel was a non-binary kid,
Okay.
going by they, them pronouns. Obviously, I've seen pictures of Nathaniel dressed more feminine and dressed more masculine, really just exploring that gender non-conforming way of being, which so many
Sure.
people are right now, especially our kids, which I think is really cool, frankly, because we didn't even have that option when I was a kid, you know.
Yeah.
As a gay kid, I never had any of these options. I didn't even know that was a thing. And
Yeah.
so I am happy for our youth that they have more options. But unfortunately, on May 20th, Nathaniel was shot and killed. This happened on May 20th, shortly after 9 p.m. The Saline County Sheriff's Office got a report of, at the time, was called a residential burglary in progress at a home on Chapel Road in Raleigh, Illinois. It really wasn't a burglary, I don't think. And deputies were sent out to investigate. When they arrived, they found Nathaniel suffering from a single gunshot wound.
Oh, no.
Emergency medical treatment was started, and Nathaniel was transported to a local hospital. And Nathaniel later died from the injuries sustained in the shooting. So this immediately became a homicide investigation.
Damn it.
Yeah. So Illinois State Police got involved, and they processed the scene, did the usual interviewing of witnesses, that kind of stuff. There's a lot we don't know yet because this is very early, as you can imagine. Initially, though, there were questions about whether or not this was a defense of home and property situation or not, or was this an unjustified shooting that is in fact murder. On May 22nd, so 2 days after Nathaniel was killed, police arrested Justin Maloney. He has been charged with multiple counts of first-degree murder. There are different kinds of first-degree murders. It's not that there were 3 murders. It's just, we've seen that before, where they charge them with multiple types and then give the jury the chance to determine Which one is it going to be? This is Maloney. Now, some of the information that I have is from the news, and some of the information that I have is from Justin's aunt. Let me tell you a little bit about what the family says has happened. And remember that this is direct information from a family member, and we just take that with that knowledge. How's that?
Yeah.
The family believes that Nathaniel was being groomed by an elderly man, and that Nathaniel had gone to his home on May 20th, and that the man's grandson, who is Justin Maloney, didn't like that his grandfather was associating with gay people, LGBTQIA people of some sort, and that he shot Nathaniel.
My God.
And that Nathaniel, said, please, I'm only 16, don't hurt me. That's what witnesses are saying. And then, I'm sorry, I said one shot. It's not one shot, it's two. Initially shot him, waited 6 seconds, and shot him again.
Oh
Now,
my God.
that's very important when it comes to the claim of self-defense. That 6-second pause,
Yeah.
when someone is already shot and down, is a great indication that this was not a self-defense murder, by the way.
Yeah.
Yeah. So he is now charged with first-degree murder.
Good.
One thing about this case is that Justin Maloney is related to the county treasurer. So the local county police can't have anything to do with this case, which is why the state police are actually doing the investigation.
Good. Okay.
For that reason. But Nathaniel's family absolutely believes that this was a hate crime, and they want it charged
Yeah.
as such.
Sure does sound like one.
It has not been charged that way yet. However, this is a very new case.
Yeah.
And so fingers very, very crossed that if that is in fact the case, that Justin Maloney will get charged with a hate crime. He could in fact also then face not only state charges, but federal charges as well.
Mm-hmm. Throw all the books at this crazy fucker. By God.
Absolutely. Absolutely. It is disgusting. He is horrifying. And what he did to this child is just, it's heartbreaking. And I'm so sorry to Nathaniel's family that this has happened.
Yeah. Yes, my heart is just sick for them.
Yeah. So they did have a detention hearing on May 28th. The state wanted him held without bond.
Mm-hmm.
And because of all of the factors of this case, that there was no way that this guy was safe to be in the community, the judge did agree, and he's being held without bond.
Good.
So he is in the Saline County Jail pending trial.
Also,
Lots
big
of
props to the
things.
police, at least I hope so, that they brought the state police right in so that hopefully discovery is preserved and things are done correctly.
Yeah, that there's no question about chain of custody or anything like that. That's really that's very important. So yes, that's good that they've done it that way. And that's what we know right now. It's not a lot, other than Justin's family is absolutely reeling. Or I'm sorry, Nathaniel's family is absolutely reeling. Justin's family probably is too, frankly.
Yes, well,
considering the known relationship between Nathaniel and Justin's grandfather.
Good Lord.
So,
yep.
Yeah. So we will continue to follow this. Justin Maloney is now on my tracker. so that we will follow this case through the court system. But
Yeah.
he is headed for trial. And I really, really hope that there are amended charges coming to add the
hate crime.
bias crime or hate crime or whatever Illinois calls it.
Yeah.
And I really hope that the feds get involved too. Right.
Yeah.
And grandpa, if this is the case that he was grooming this kid, then he's also a
Right.
predator.
Absolutely.
And that needs to
all
be looked at
come to
as well.
light. Definitely
Yes,
that. Yeah.
every bit of this does, for Nathaniel's sake and also for the sake of other young people in the
Yep.
community.
Yep.
Yeah.
Yep.
Absolutely.
They need to blow the entire lid off of this. Yep.
Yes. Yes, they do. And fingers crossed, the family is really working for that. And the advice we'll give you, family, as we do everyone: never stop talking about this. Stay in the news, put the
Yep.
pressure on, write letters, do interviews, get one of the reasons that we're
Have
talking about it is
vigils.
to
Yep.
have vigils, get every podcast in the land to talk about it, because the more pressure that you put on your local officials, the more likely you are to get a real outcome here. And that's really important.
Yep.
And the hate crime charges, they need to come.
Yeah.
If the things that were said that are being reported by the family, and it's likely that they know that because the police know that, it's pretty clear
Yep.
that this is a hate crime. So
Yep.
let's keep the pressure on in Illinois to make sure that this is charged that way.
Absolutely. Yep.
Yes.
Yes.
All
And
right.
Christine, all of our love to your family. And
Yes, absolutely.
feel free to shoot us an update every time.
Yes, please
An
do.
email every time there's an update. Because, stuff like this falls through the cracks for us. We go through, you can imagine, a tremendous amount of information all the time.
Yes.
So make sure, send us an email, make sure we see it. We will keep talking about this case.
We absolutely will. We absolutely will. And with that, Katie, I'm going to kick it over to you for a True Crime Squad Trials update.
Yes. For the longest time, it really seemed like the justice system was getting this one wrong. We felt like when this went to trial that there was no jury in the land that would put Aaron Spencer in prison. And yet, you just don't know. And a miracle has happened. Apparently on June, just today, June the 4th, Aaron Spencer's charges have been dismissed by the judge.
Yes.
We're going to go through why.
Finally.
Yes. So I want to talk briefly about Aaron's case in case you don't remember, but this is a case in Arkansas in which a young child, a 13, 14-year-old girl, had been being groomed and sexually assaulted by a 67-year-old man. Many of you remember this case. We've talked about this case quite a lot. So I would imagine that many of you remember exactly what we're talking about. But Michael Fosler was the perpetrator. Fosler was arrested. He was charged with over 40 crimes involving the things that he did to this child. And he was immediately bonded out on a very low bond, which was insane from the get-go. Fosler
Unimaginable.
did not stop trying to contact this man's daughter. She had hidden electronics in her room. He was still sneaking around the system and making contact with her. Well, one night the Spencers woke up to the daughter's dog barking in the middle of the night on October 8th, 2024. This was about 1:13 a.m. And listening to the dog bark, Mom got up to check on her daughter, who was gone, not in the home. So the Spencers call the police, and Aaron does what any dad would do. He gets in his truck and he starts driving, looking for Fosler's truck, knowing he probably isn't very far. We've got to find this man. And at this point, you can imagine his trust in the justice system is probably pretty iffy, right?
Yeah, mine would be.
He finds Fosler driving down the road. Tries to get him to pull over. Fosler will not. He can see his child in Fosler's pickup. She has been kidnapped by the perp. He ends up doing a bit of a pit maneuver and running him into a ditch and trying to get his daughter from the car. In the process of that, Fosler tries to fight back. There's an altercation. Aaron Spencer shoots Fosler and he dies. Initially, one of the claims from the prosecutor's office is that they were charging uh, our man here because he emptied an entire clip into him. He didn't shoot him once, he didn't shoot him twice, he shot him like 15 times. But Aaron Spencer
If
was.
you're defending your child,
Yeah.
empty that clip.
Aaron Spencer was saying that he was acting in support of another, or in defense of another, and he was, but also of himself because Fosler was fighting back against him. So, with all of those things being said, kind of very surprisingly, Aaron Spencer was immediately put in a police car and charged with first-degree murder.
First degree.
Eventually, those charges were actually pretty quickly. Those charges were reduced to second degree, but still, he's charged with murder.
Yeah.
The judge on the case is the same judge who let Fosler bond out with a little tiny bond for the charges he was charged with, and immediately gagged the case. She gagged the case so hard that the victim couldn't even receive therapy because talking about the case at all was breaking the law. Nothing could really proceed forward with this case because of the gag order. Because, the judge didn't seem to want anyone to know anything about this case in any way. Aaron Spencer's attorneys went straight to the Arkansas Supreme Court and said, we have got to have this gag taken off. This is unconstitutional. It's insane. And the Supreme Court agreed. They said two things. Well, they probably said more, but the two things I'm going to talk about. They said, first of all, the gag is off. Second of all, this judge should recuse herself because she was a little too close. She was already overseeing the judge or the proceedings against the now victim, Fosler. He's not really a victim, let's be real. But they said she should recuse herself from Aaron Spencer's case. The judge, however, said, nah, I'm not going anywhere. So she continued for the next year to be very, very difficult for the defense to deal with. However, Aaron Spencer was able to bail out. He's been out all this time, luckily. However, this has been a huge hardship on his family, as you can imagine. There have been quite a few fundraising efforts, crowdfunding efforts to help pay for his defense. Eventually, things with the judge were so contentious and so difficult that the defense went back to the Arkansas Supreme Court and said, she's got to go. And they said, you know what? You're right. She does. And they forced her off of the case and they got a new judge. When they got a new judge, we had said, maybe this judge will dismiss these charges. Maybe he's the one that will look at this and dismiss. He didn't initially. Initially, they were scheduled to go to trial, like in a couple weeks. This was starting
June 22nd.
Like now. Yeah. And so just a few days ago, last week, the defense filed yet again for dismissal based on discovery issues, based on evidentiary issues. And we talked about this a little bit on the show last night. And the state came back with basically, okay, so we lost some stuff, but like we didn't do it to be jerks. It wasn't in bad faith, so you can't really punish us for that. Well, the judge...
Are you kidding me?
The judge disagreed. So I would like to read you the Aaron Spencer dismissal doc. This is 19 pages long. I'm going to skip over some of the legalese and stuff like that and mostly just tell the tale that the judge is acknowledging. Actually, though, before I do that, I'll put something else up here for you to look at. Okay. This is order granting defendant's motion to dismiss for due process violation or alternatively for spoliation instruction.
And it's due process
Spoliation, sorry. Yeah, due process violation or spoliation instruction. After a careful and thorough consideration and review of defendant's motion to reconsider ruling limiting 404A evidence, to enter order setting aside prior order as to expert witness, and to enter order granting relief for state's destruction of evidence, filed on April 20th, 2026, state's response to defendant's motion to reconsider rule limiting 404 evidence as to expert witness, and to enter order granting relief for state's destruction of evidence, brief in support of defendant's motion to dismiss for due process violation or alternatively for spoliation instruction, filed May 21st, state's response to defendant's motion. I'm going to go through all of those, the motions and the things that were filed that this decision is based on. So let's hit the background. According to the affidavit for warrant of arrest for Aaron Spencer by Lonoke County Sheriff Detective Robbie McCain, on October 8, 2024, the affidavit for arrest stated in pertinent part, facts constituting reasonable cause. On October 8, 2024, at approximately 113 hours, deputies responded to a call on Highway 236 East in reference to a missing juvenile. Deputies were advised that the missing juvenile had been raped and sexually assaulted by a Michael Fosler in July of 2024, and that he was known to drive a white Ford F-150. Lonoke County Dispatch requested that Cabot Police Department send officers to a specific address within their city to try to locate the missing juvenile at Michael Fosler's residence. Prior to receiving information from Cabot, dispatch received a second call from the father of the juvenile, identified as Aaron Spencer, stating that he had located the man who kidnapped my daughter, in quotes, Michael Fosler, and his daughter, but that the male was dead on the side of the road and he had no choice. Deputies arrived at said address inside the rural area of Lonoke County and located both Aaron Spencer and Michael Fosler. Deputies immediately began life-saving measures on Michael Fosler, but he had succumbed to his injuries. Detectives took Aaron Spencer into custody and secured the female juvenile away from the scene. The deputies cleared and stored the weapon, a Glock 19 Gen 4, that was found to have been on the person of Aaron Spencer and had blood on the outside of the weapon. Detective R. McCain was the first detective on the scene. Upon arriving, I observed a white Ford F-350 sitting north at the scene, angled in the northbound side of Highway 13, with a white Ford F-150 sitting next to a driveway. The white F-150 appeared to have been forced off the roadway due to skid marks located on both the asphalt surface of the highway and through the ditch line. Michael Fosler was lying on his back in a ditch on the eastern side of Highway 13. Michael Fosler had visible puncture wounds, believed to be caused by a firearm projectile, on his chest, abdomen, and both his left and right arms. Upon inspection of the white Ford F-150, damage was located on the rear of the vehicle, normally seen after impact with another object. A search of the area was performed. During the search of the area, several spent 9mm casings were found on the roadway, driveway, and ditch surrounding the white Ford F-150. Once clearing the scene, myself and Detective N. Rice interviewed Aaron Spencer at the Lonoke County Sheriff's Office. After being advised of his rights, to which he acknowledged understanding, in reference to events that had occurred, Aaron Spencer stated that he had been woken up by his dog barking, which was uncommon, and went to check on his daughter's bedroom due to the events that had occurred earlier this year. Aaron Spencer further explained that he looked closer at what he thought was his daughter in bed. He realized that it was actually a stuffed animal with his daughter's hoodie on it. Aaron Spencer stated he became scared of what had happened to his daughter and had his wife call 911 to report her missing. Aaron Spencer then stated that he left his residence and began to search for Michael Fosler and his daughter. Aaron stated that when he arrived at the intersection of Highway 236 East and Highway 31 North, he observed the white Ford F-150 belonging to Michael Fosler turn off of Highway 31 onto Highway 236 East, headed towards his residence. Aaron Spencer then stated that he was in fear for his daughter's life and continued to pursue Michael Fosler east on Highway 236 East. Aaron Spencer explained that when they arrived at the intersection of Highway 236 East and Highway 13 North, he hit Michael Fosler's vehicle in the rear, causing it to slide off the roadway. Aaron Spencer then stated he exited his vehicle with his firearm in hand and ordered Michael Fosler out of his vehicle to lay down in the ditch. Aaron Spencer stated he observed his daughter trying to exit the passenger side of the vehicle, but it appeared that Michael Fosler had grabbed her and stopped her from getting out. Aaron Spencer then stated that Michael Fosler then lunged towards him saying, "Fuck you." Aaron Spencer stated that he then opened fire on Michael Fosler, emptying his weapon before jumping on top of him and pistol whipping him. Aaron Spencer then stated he got his daughter out of the vehicle and returned to his truck, where he reloaded his weapon and called 911. Portion 2, Judicial Notice. This court takes judicial notice that the victim in this case, Michael Fosler, was charged by information on September 4th, 2024 in the Lonoke County Circuit Court in case number yada yada with 43 sexual-related offenses, 2 of which were Class Y felonies, with defendant's minor daughter as an alleged victim. The alleged offenses were between June 1st, 2024 through July 5th, 2024 in Lonoke County. There is a faint copy of an unfiled form document under the heading in the Circuit Court of Lonoke County, Arkansas, with pending charges box checked styled pretrial order in the case of State of Arkansas versus Michael Fosler in handwriting, with a date of July 12, 2024 filled in, showing a bond amount of $50,000 with a form box check stating the defendant shall have no contact, either directly or indirectly, in person, by telephone, mail, social media, or any other means with any minor or his or her immediate family or friends. The court also takes judicial notice that Michael Fosler did not appear before a Lonoke County judge for a first appearance Rule 8.1 hearing. Although the document referenced above was in the Lonoke County Circuit Court, it was signed by a Lonoke County District Court judge, was unfiled, and wasn't discovered by defendant's discovery request until late 2025. Furthermore, Michael Fosler's first appearance in Lonoke County Circuit Court was on September 6, 2024, when he appeared with counsel H. Alexander, entered a waiver of arraignment with a pretrial date set for December 3, 2024, and a jury trial set for December 12th through December 6, 2024. Under our legal system, Michael Fosler was presumed to be innocent. Then he discusses some applicable case law. I'm going to skip over that, but I did link this document in the show notes, so if you want to read all of that, you can. Section A, Bad Faith Prong. The Lonoke County Sheriff's Office has a detailed policy, 16.1, effective in 2014, that sets out policies and procedures for handling the processing of evidence. At issue here is the dash camera found by Lonoke County Sheriff's Office, deputies, and a detective on duty in the alleged victim Michael Fosler's truck at the scene of the events, giving rise to this case in the early morning hours of October 8, 2024. The dash camera, mounted on the front windshield, is just to the right of the rearview mirror of the decedent's truck, had dual cameras, allowing it to record events in front of the truck, inside the truck, and potentially behind the truck. It might be wise to note here that Michael Fosler is former law enforcement, or was.
And he had full view. That camera had full view of this incident. And what happened leading up to it as well.
LCSO Detective Robbie McCain at the scene removed the dash camera from the windshield, one, without its original position on the windshield's truck being A, recorded, B, photographed, or C, sketched as part of the crime scene, nor was the dash camera itself photographed or recorded. that the policy here, after locating an item considered pertinent to the case under investigation, it should not be disturbed until it has been photographed, measurements taken, its position recorded on the crime scene sketch, and entered into the officer's notebook. Detective McCain's actions that morning violated that procedure. According to an inspection by Jason Stacey, a retired Hot Springs police chief, who testified under oath at a December 2025 pretrial hearing, the dash camera mount was broken when it was removed from the windshield of the decedent's truck, and the dash camera's internal settings were not preserved, and its internal battery was allowed to drain, resulting to a default setting of August 1st, 2024, which probably rendered the dash camera useless after that time. As for the SD memory card found within the dash camera, Detective McCain stated in his affidavit of December 2nd, 2025, that he noticed the dash camera had a micro SD card inserted into it. Detective McCain removed the micro SD card out of the dash camera and placed into an adapter for a regular-sized SD card into a card reader and opened it on his computer. He said he viewed 3 videos of 15 minutes and a 4th video of less than 15 minutes. He further stated that he placed the micro SD card back into the dash camera and placed it back into the original manila envelope. That is controverted by expert witnesses for purpose of pretrial hearing of December 7th and 18th, 2025, Brandon Purchase. According to Jason Stacey's affidavit, Detective McCain and Lieutenant Portali stated that the LCSO's standard practice is not to manipulate electronic devices or check for SD cards before sending the devices to the Attorney General's Digital Forensic Unit. They said the reason for this policy is not to manipulate the electronic devices at all, because doing so takes a chance of wiping data and everything else. Furthermore, Stacey said that Detective McCain was trained not to remove SD cards because of the risk of wiping data, and that Detective McCain, like other LCSO officers, generally does not check whether a device contains expanded memory. Finally, according to Stacey's affidavit, Detective McCain said they disliked manipulating any other equipment before it was sent to the AG's office. And yet, in this case, he did. After removing the SD card from the dash camera, Detective McCain did not photograph the SD card, record its data storage size, or mark it as a separate item of evidence, contrary to LCSO 16.1. Actions taken by Detective McCain in this case appear to violate Section 2, Identification of Evidence. All recovered evidence must be immediately and properly marked or labeled in order to assure its proper identification at some later date. Further, each piece of evidence must be marked when it is removed from the original position. Evidence will be marked by use of deputies' initials and evidence case number when practical. The date of recovery, case number, and similar identification shall be fixed to the exhibit whenever possible. Additionally, Section 3, Preservation of Evidence, states, the integrity of evidence may be further protected by selecting a container that will guard against damage or contamination. A. Place each item in its own container or paper wrapping. B. After the article has been marked, place in a container and sealed with a label or tag will be affixed. C. Deputies must also log all property in the property section of their report in the SOMS so that the evidence custodian can properly maintain chain of custody. Next, chain of possession. The correct methods used in collecting, identifying, and packaging evidence may be nullified if an officer cannot account for all persons who have handled, examined, or stored the evidence. Each deputy is responsible for maintaining the chain of possession and protecting the integrity of his/her evidence. If the evidence leaves the deputy's possession, he or she should record their notes to whom it was given, the time and date, the reason for it being given to another person, and when and by whom it was returned. The court finds that Detective McCain's actions did not comply and violated LCSO Policy 16.1 in the ways enumerated. Another area of concern is the information contained within the Tim Griffin Attorney General Request for Forensic Examination form. That form shows an item of evidence, E1, a black and silver 1080p camera was submitted by Sergeant Carla Lucas on 11/14/24 and received by SA Amber Colmer. Within the large box on the right upper hand of this form is the on-site preview, checked UNK, presumably for unknown. This item of evidence, presumably the dash camera, was returned to the Lonoke County Sheriff's Office on 10/16/2025, 11 months later. In the LCSO evidence detail form, it was listed that this evidence was sent to the AG's office on 10/14/2024 and checked back in from the AG's office on 10/16/2025. This form indicates the acquired location was Michael Fosler's windshield, and this item of evidence was acquired on 10/8/2024 at 4:13, acquired by Robbie L. McCain and given evidence number E85. Between those two dates are a series of emails between the prosecutor and defense counsel on July 3rd, 2025. The first email is a disclosure from the prosecutor to defense counsel to let her know about a dash cam that was apparently in the decedent's truck that was taken into evidence by LCSO after the incident, and that Detective McCain took the micro SD card out and reviewed the files on it, but all the files showed to be after the incident and just showed blue lights in the background and no other exculpatory or inculpatory evidence. That email also indicates that the dash cam unit, along with the SD card, were sent to the AG's office for Amber Colmer to do a forensic exam on it, but it has come up missing. That email also referenced Detective McCain unplugging the dash cam. A follow-up email stated that there was no internal storage within the dash cam, and that is the crux of this missing, lost, or destroyed evidence not preserved by the state. The court is unable to discern when the Attorney General's office informed LCS that the memory card was missing. There's one last discrepancy before moving on to the December 17th and 18th pretrial hearing transcript. This LCSO evidence detail form also indicated this dash camera of evidence was sent to the AG's office on 10/14/2024, whereas the AG form listed above shows that office received this dash camera on 11/14/2024, as stated in a paragraph above. The state asserts this is a clerical error. Sure, a lot of effort or errors on the state here. Detective McCain's testimony at December 2025 pretrial hearing points. Number 1, Detective McCain did not photograph the dash camera position or location and did not document its existence in the incident report. 2, Detective McCain admitted that the camera was not logged into evidence, but was instead stored in his personal office rather than the evidence room. An oversight, it wasn't logged into the system and it got missed.
Oversight, sure.
Yeah. 3, the dash camera was not logged as evidence until over a year after it was collected, a violation of preservation of evidence procedure. 4, Detective McCain removed the memory card from the dash camera before logging it into evidence and viewed the contents on the computer in his personal office. 5, Detective McCain said this was the only dash camera LCSO has ever seized during an investigation. 6, after viewing the contents of the memory card, Detective McCain testified he placed the card back inside the camera, placed the camera in an untaped envelope, and put the envelope in his office cabinet rather than logging it into evidence. There's a note here. Pretrial expert witness Brandon Purchase noted the SD memory card snapped securely within the dash camera. 7, Sergeant Carla Lucas took the dash camera from LCSO to the AG's office on 11/14/24 for examination. 8. The AG's office did not receive the SD memory card containing the data from the dash camera. 9. None of Detective McCain's actions regarding the dash camera was documented in any database or log, a violation of LCSO written procedures. 10. Detective McCain's failure to place the dash camera into evidence resulted in the camera not being logged into the system of evidence until 10/16/25. That is an entire year that the dash cam was not placed into evidence. 11. There was no mention.
What could have happened?
Right? Why would that be? There was no mention of the existence of a dash camera in any discovery or law enforcement document until it was returned from the AG's office on 10/16/25, when Detective McCain listed the dash camera into evidence as item E85. The SD memory card and dash camera should have been listed as two entities if separated. 12. LCSO typically sends electronic/digital evidence, computers and phones, to the AG's office for examination. In this case, with the exception of the dash camera, LCSO sent all of the other items, including memory cards, phones, computers, tablets, etc., to the AG's office without first attempting to view them in office. So they did all of the other things right except for the dash cam.
Except for the dash cam. Why?
Mm-hmm.
What's the real reason?
And the state
'Cause
emails the
we
defense.
just made a mistake bullshit. Are you
Mhm.
kidding me? Come on.
Well, and the state emailing the defense and being like, so yeah, I mean, this happened. It's not a big deal. You couldn't see anything anyway. Take our word for it. It's fine. And it wasn't in bad faith. So what you gonna do?
A real trust me bro situation gone wrong.
Yeah. 13. Detective McCain did not document accessing the SD card or what he said he saw when he did so. As an aside, there is a reasonable possibility that he didn't see what he said he saw, based on the sworn testimony of expert witness Brandon Purchase and the affidavit of Jason Stacey, that powering off the camera does not delete anything from the SD card. However, the court was not present at the pretrial hearing, so no credibility filings can be made. Okay. Other testimony. We're going to get there, you guys, I promise. I'm sorry this is long, but I think all of it was so important. Other testimony during December 2025 pretrial hearing. Number 1, LCSO Lieutenant Portali stated that Detective McCain's 1. Failure to document the removal of the dash camera from the decedent's truck. 2. Failure to document pulling the SD card out. 3. Failure to document what he purportedly saw, and 4. Failure to document its loss, all violated policy. 2. There was other testimony at this pretrial hearing that indicated that the decedent's truck accessory was still powered up and running the video camera, that Detective McCain unplugged the dash camera, it powered down, and that a splash screen went off, which was disputed by Brandon Purchase, but the court will not make a credibility finding on that issue. Yeah. There were things on that they didn't want anyone to see.
There sure were.
3. There was other testimony at this same pretrial hearing that indicated that Attorney General Special Agent Camber Calmer found no SD memory card when she opened the package containing the dash camera, and that there were 6 SD memory cards found in the decedent's house and 6 SD memory cards found in the decedent's truck in separate searches by the LCSO. In view of these cumulative deviations from the LCSO policy and procedures and outright violations of these procedures and best practices, and intentional actions of law enforcement in not preserving the critical SD memory card, it has been lost or destroyed. This establishes a pattern of policy and procedure violations and gives the appearance of a cover-up. God, judge is going all in. The state argues that these series of violations were mistakes, errors, negligence, and unintentional not amounting to bad faith. We're not trying to hurt your
Are you
feelings, Erin.
serious?
The state further argues
Not
that,
in bad faith. Give me a
yeah.
break.
The state further argues that the definition of bad faith is limited to the definition set forth in the Starks case. That case also said, citing Trombetta, when law enforcement followed their standard operating procedures typically shows a lack of bad faith. Conversely, it could be logically argued that failing to follow standard operating procedures is evidence of bad faith when combined with other factors, as is here. Defendant has cited cases from other jurisdictions that define bad faith. I'm going to skip over some of this. Okay, let's get back to the dash camera. So B, the dash camera and SD memory card as potentially useful evidence in defendant's case prong of the argument. Transcript evidence at the December 2025 pretrial hearing. LCSO officers McCraney, Lucas, and McCain acknowledged the evidentiary significance of the dash camera. 2, both Deputy McCraney and Detective Lucas answer yes when asked if they immediately recognized the dash camera as an item of evidentiary value. Defendant has advocated that it is logical and legitimate that the dash camera would provide exculpatory evidence, assuming the dash camera was working and was operational, as it was plugged in at the time it was removed. Defendant asserts that the working dash camera would have provided 1, the decedent's custody of defendant's daughter, 2, the decedent's directives to defendant's daughter in the truck, 3, defendant's attempt to get the decedent to stop the truck and the decedent's refusal to do so, 4, the decedent's active fleeing from the defendant with defendant's daughter in the decedent's control, 5, the defendant's successful effort to safely maneuver the decedent's truck into a driveway, 6, the decedent's aggressive exit, including the language he used when he exited the vehicle. The court further notes that the state, in its response, agrees with defendant that the dashcam and SD card possessed potential exculpatory value and would have been potentially useful for both defendant and state. Based on the evidence and the defendant's argument, the court finds that defendant has proven his prong, thus satisfying both prongs of the second test under the Clark's opinion. The state also violates the due process clause when it destroys or loses evidence. 1, that is potentially useful in the defendant's case, and 2, when the government acted in bad faith in the destruction of the evidence. The court will also address the other test requiring defendants to prove 1, that the exculpatory value is apparent, and 2, that the defendant cannot obtain comparable evidence by any other reasonable means. A, exculpatory value of evidence is apparent before destruction prong. Defendant addresses this prong as his first point in the brief of May 21, 2026. This issue is intertwined with the actions of bad faith discussed in prong 1 of the first test herein. The second prong of the first test, evidence that was potentially useful in the defendant's case, is also related to this prong of exculpatory value. Defendant's brief thoroughly and extensively addresses this prong with facts and arguments, which the court finds persuasive. The court finds that the defendant has met his burden of proof to this prong, the exculpatory value of the dash camera and its internal memory card before it was lost or destroyed. B, the defendant's inability to obtain comparable evidence by reasonable means prong. As defendant points out in his brief, video and audio of the dash camera, assuming it was functional and recording, would have demonstrated what defendant would have witnessed and experienced in real time. Video evidence is objective and not altered by human perception or bias or self-interest. Defendant correctly asserts that he has a Fifth Amendment right not to testify and cannot be compelled to testify, so his own testimony cannot satisfy the comparable evidence factor. As argued by the state in its response, the only other eyewitnesses to the events of this case was the defendant's daughter. However, her testimony may be colored by the stress and trauma of the events of that late night/early morning. Dash camera footage would be the only objective evidence of that early morning encounter. Defendant cites in his brief 3 federal district court cases from Utah, Idaho, and Michigan. In all 3 cases, video evidence was available, but unfortunately, no video evidence is available in this case. These courts reinforce common sense that competent video evidence is objective and neutral and not subject to human biases or deficiencies in perception. These federal trial court cases are helpful and persuasive, even though they are not precedent for a state court, but their holdings do assist defendant in meeting his burden of proof on this point. Therefore, the court finds that the defendant has met his prong as to the first test. Remedy. Defendant Aaron Spencer filed notice of intent to raise justification as a defense on December 3, 2024. Specifically, defendant has raised the defenses afforded to him in Arkansas Code, blah, 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 having found a due process clause violation under both tests of State v. Clark. The court finds that the loss or destruction of the internal SD memory card of the dash camera has adversely impaired defendant's ability to defend himself pursuant to these defenses and thus his right to a fair trial. The next issue is that of a remedy in this case. The last paragraph of the Clark's opinion noted that none of the cited cases mention the appropriate remedy if a due process violation is found. That there may be occasions when conduct by law enforcement is so egregious that it warrants dismissal, but those should be outliers. The state argues that this is an extreme remedy.
Extreme remedy for extreme violation.
Therefore, the court acknowledges that dismissal is an extraordinary and extreme remedy. However, based on the totality of the circumstances and the unique, specific, and particular facts and circumstances of this case, the court finds that conduct by law enforcement was so egregious that dismissal of this case is warranted. Therefore, this case is dismissed. It is so ordered. Signed by Ralph Wilson Jr. And there it is. And that is a mouthful, but amazing.
Thank you, Judge Wilson.
Oh my God. Yeah. Crazy.
Why?
It's
what
crazy
was on
to me
SD
that
card?
no one thought this case should come to trial for very obvious reasons.
Yeah.
And yet it's being dismissed because of evidentiary issues.
Well, I would
of egregious
imagine
mishandling by the police.
Well, I mean, it's due process violations, it's constitutional rights violations.
Yeah.
Also, it looks better on paper.
Yep.
For it to be a constitutional rights violation than
Yep.
it to be, this was obviously defense of another, you know, like,
right.
This
you
is.
You have to wonder if the judge was just like, no. And this is why we can release this. Yeah. I mean, he'd never admit it, I'm sure, but come on, man.
Yeah.
Just
well,
an
and like somebody
situation.
said, he's saved the real victim in this case, Aaron Spencer's daughter, from having to go through this trial, which honestly, that is an absolute blessing. That poor kid. Jesus.
Absolutely. We don't know the answer to that. Jules wanted to know, did these current officers ever work with Fosler, with the kidnapper? We don't know.
We don't know.
But they sure did go to lengths to try to protect him in this county.
They did. Yep.
Yep. But what the hell was on that?
Yeah. Well, here's my question. Did it implicate more than just Fosler?
Yeah, that's a dang good question.
Was there stuff on that SD card that implicated other members of this sheriff's office or something? Like,
right.
Who were they protecting? Were they really protecting Fosler, or were they protecting someone else too? It does make you really wonder, like, if it really just shows the situation and that Aaron Spencer was fighting for the life of his child, why would they get rid of it?
Right. Right.
Why would they protect a pedophile cop?
Right. Why?
Yeah.
Yep. This whole county needs to be blown open, and
Hmm.
maybe
Well, it's going to be because they're probably going to get this guy for sheriff.
they probably
That's
are.
just the part that's so damn funny to me.
Now, Aaron does not have law enforcement experience, but he is former military. So
Yeah.
he's got some stuff going for him here. I mean, this man managed to, during the kidnapping of his own child, do a pit maneuver, get uh, the perpetrator out of the vehicle, and, well, I'm going to say detained, but also dead. But, without his daughter getting hurt, which is
Yeah.
pretty amazing.
It really is. It indicates the dude has some serious skill.
But
Well,
if
and
you
just to have found
think,
them in the first place.
yeah,
Like,
yes, absolutely.
good
But if
instincts.
you think that her life wasn't on the line, you're wrong. It
Yeah.
was. She was going to be the key witness in 43
His trial.
sex crimes against this man. What was
Yeah.
he taking her to do?
Right. What was he taking
Would
her
that
to
have
do?
been her last life on earth? Or her last day on earth? Because it sure makes you
Right.
wonder
It really
why.
does.
I
Yeah.
mean, the obvious reason would be, well, he was a sex offender and he wanted her back, and okay, maybe. But was it more than that? Was he going to get rid of
Yeah.
the witness? Like,
She was the whole case against him.
yeah.
Yeah.
Yep. Her life was absolutely, unequivocally in danger that night. There is no question.
Yeah.
Yep. So,
What would anyone else have done in this situation?
my husband
Just
and I have
let the
discussed
guy
this
take your
so
kid?
many times.
No way in
Yeah.
hell.
No, absolutely not. Yeah. So, I've been watching for a statement from the Spencers. I haven't seen one come out yet, but I was a little busy reading, so I can't say for sure.
I can
That one
check.
hasn't, but I haven't seen anything as of now. But I'm sure there'll be one forthcoming. They've had a lot of community support. Honestly, Aaron's wife has been an absolute rock star in this case, and I think just been the backbone of her family, trying to hold everybody up. I can't even imagine the amount of relief she is feeling today.
Oh my God, right?
And
Just for
that's one
their
thing we
entire
don't
family.
know, Irene. So it seems though she kept in contact with him, but she go with him willingly? I mean, in the face of the law, she couldn't have because she was only 14. So she couldn't consent to go with him. However, did she dress that teddy bear up in her hoodie and climb out the window or whatnot, or sneak out the front door? We don't know. We do know that he still had contact with her via. I, I'm going to say this, but this was reported really early on, so you can check me on it if you need to. But very early on, it was reported that they had found an additional iPad or tablet in her room they didn't know about, that she did still have contact with him on. So we don't know. Yep. Yep. Right. Would you not be
Yeah.
out of your mind trying to protect your child? Yeah. Right?
Yeah.
Tall Red? Yeah. And I wondered that too, Bethy. Is it possible he threatened to harm her or harm her family? Fosler had no limit of what he would do. There was no bottom for him. So, yeah, maybe he did. We don't know why she went with him. We just don't know. Except for that he had done such a number on her psyche and her way of thinking that
Yeah.
who knows. Being 14 is hard enough, you know?
Right.
So that's what we know. So, congratulations to the Spencer family. There were some questions that have come up about whether or not they could recharge him. The short answer is probably this wasn't done without prejudice, but the same problems would remain. And so it's really unlikely that they would do anything of the sort because they would probably just get kicked right back out of court with it because they still have the same evidentiary problems. The only thing they could do is come up with the SD card. But even then, the chain of command situation, the way the entire dash cam was treated, like this is never going to trial
No. No.
in any day or night or capacity. It's just not.
Yeah. No way in hell.
Yep.
And with the constitutional rights violations, like,
Yeah.
what are they going to do? There's nothing they can do. This is done.
Yep. Yep. It's over. Makes me so grateful for Aaron Spencer that he was able to bond out and that he's been out all this time and hasn't been sitting in jail for the last 18 months. Yeah.
Right.
It's a good point, Jules. Were they embarrassed that he got to them first? I wondered about that too. If they just didn't like that Aaron Spencer got there first, they didn't like that Aaron Spencer was the hero and not them.
Yeah.
Or did it have to do with their relationship with Fossler? That really needs an internal examination.
Well, it does. Like, what really happened here, and what was going on? Like, what was on that video? What was on that SD card?
Yeah.
What were they protecting, or who were they protecting?
Yeah.
Yeah.
A lot of good questions, right? Do there need to be charges for detectives and others? That's a good question. Do those detectives still work there?
I mean, intentional destruction of evidence in a murder case? What?
Considering that they handled all of the rest of the electronics appropriately and just didn't with this one. And then they're like, oh, yeah, sorry, but it wasn't bad faith. It was just, we're bad. But it's okay. Like, listen, our detective watched the videos and he said you really couldn't see anything anyway. So, see, no harm, no foul. And think they could just get away with that? But the thing is, they were getting away with that. They were getting away with that with the other judge.
They were.
I have to believe that even if this went to trial, even if they got a conviction, which I just still in a month of Sundays cannot imagine, this would have gone back to the Arkansas Supreme Court and they would have had to do something about it.
Yeah, absolutely.
Right, Irene, good point. She said our officers have to have cameras running at all times, especially when handling any potential evidence. Right, there was absolutely no conversation about his body cam.
Yeah.
Yeah.
Yeah. They were protecting somebody.
Yeah. You can't tell me this wasn't intentional. You just can't. Even the judge said this smells like a cover-up.
Yeah.
That's pretty strong words from the judge,
That is. You don't hear a lot of judges say something like that.
No, he could have left it at, hey, evidentiary issues, they met the prongs because all of these things were done wrong and dismissed the case without saying that. He didn't have to say that, but he did.
No, he didn't. But it was so obvious that was the case.
Yeah.
Just, wow.
Yeah. So I think just based on time, because we've gone a long time here, we're going to hold over our last case from today for Monday.
Mm-hmm.
And also our main case that was supposed to be our main case for Monday, because this information reached me 20 minutes before the show started. So I scrapped the case I had all prepared and brought you this one instead because, hello, how could I not?
Yeah. We wanted to definitely bring you the Nathaniel Potts case as well.
Yes.
So it just sometimes works out how it works out, doesn't it?
Yep, and those were the two driving factors today. I know True Crime Squad Trials has, we have a sentencing tomorrow.
We do. We have the Brendan Banfield sentencing tomorrow. I will begin at 9 a.m. Mountain. I know it will start earlier than that, but that's what we do. So come join us over on True Crime Squad Trials, where we have the nicest chat in true crime, and watch the Banfield sentencing with us. Apparently, they did the other hearing on the, asking for a dismissal today.
Yeah.
I don't know. These guys have been kind of a shit show the last few weeks. I will get that up so that you can see it. But it doesn't really matter because it's really the sentencing that matters, and that will be tomorrow. So join me at 9 a.m. Mountain over on the Trials channel. True Crime Squad Trials.
Awesome. All righty. Well, thanks so much for being here. Have an awesome weekend. Please go touch grass, have fun, do something awesome, do something creative, or just lay on the couch. It's up to you, but take good care of yourselves. Absolutely. You sure deserve that. This has been yet another production of the True Crime Squad.
Bye, everybody.
Join the Super Squad, bonus laughs, deeper clues, same sharp sleuths, just extra clues.